May it please the court, Brian Gowdy on behalf of the appellant, Mr. Lindon. I'd like to reserve about 6 minutes of my time for rebuttal. The DHC, the appellee here in its brief, has clouded the primary issue on this appeal. It is focused on a subsidiary argument in our initial brief, spanning about a page, on whether a trial judge may order a new trial when the evidence conflicts. The cases on this subsidiary issue, I concede, are not entirely cohesive, but it does not.
When you're talking about the weight against the manifest weight of the evidence, what does that mean?
It means that there's almost no evidence or very little evidence that supports the jury's verdict.
But I mean, by definition, there has to be some evidence, or there wouldn't be a new trial. There'd be a judgment notwithstanding the verdict, or judgment or a directed verdict, right? Got to be some. In other words,
well, there has to be some evidence that supports the verdict, or you would go to. I think there's two standards we're dealing with, right? The JNOV, which was the last appeal, right, which is when there's no evidence or right, zero evidence, right, and here we've just sort of moved.
I don't know if it was a he or she, but the trial judge was wrong about that. But
right.
But this is a different animal, right? Against the manifest way of the evidence.
It's different, but it's still a very demanding standard for the moving party, which is DHC.
But it does. I think your opening proposition was it doesn't give the trial judge, the authority to weigh conflicting evidence. But that's exactly what it does, isn't it?
No. I disagree. I think that the trial judge may not resolve conflicts in the evidence. There may be some conflicting evidence in the record, and I guess I like to think of it as a scale. And when you have directed verdict, you have to show that there's no evidence on one side favoring Mr. Lindon in this case. If you're dealing with manifest weight of the evidence, there may be a little bit of evidence, some evidence on behalf of Mr. Lindon's side, but nothing else.
What about the trial judge's conclusion that the jury was deceived as to the force of the form I-9 because of testimony about its, whether or not it was filed with the government or required by the government? What do you say about that?
Well, I think the trial judge was wrong. Well,
you wouldn't be here.
The only testimony on this point was from Mr. Dalton, the president of DHC. That is the only testimony in the record about it being filed.
Misrepresentation.
I'm sorry?
Mr. Dalton made the misrepresentation.
I think that there was a misunderstanding by Mr. Dalton and some of the lawyers involved, but remember, the argument of counsel is not evidence, about whether or not it was filed. I don't think whether or not it was filed is very important.
Did the jury know, as a matter of fact, that it was never filed with the government?
There was testimony from the corporate secretary, Ms. Hurt, that it was not.
It was not.
And then once that testimony came in, the lawyers who were arguing the case stopped saying that.
So there was direct testimony that it was not filed with the government?
Absolutely. By Ms. Hurt. We cited in our brief.
Was there argument in the closing argument that it had been filed with the government? You said that the lawyers had stopped once Hurt testified.
No. Once we got to the closing argument, there were things like it was represented, this was an official document, which is true. There's nothing deceiving about this. You fill out an I-9 form, that's an official document that later on the agency.
I'm talking about whether it was actually filed with the.
No. There was no argument, and more important, and perhaps just as important, Your Honor, there was no objection to this argument. I mean, this is trying to get around Murphy Robotics now. This is trying to say, well, we didn't object at trial, so we'll come in through this manifest weight of the evidence and deceiving the verdict motion for a new trial. There was no argument and there was no objection, and they want to get a second bite at the apple.
The trial judge was apparently concerned that whatever testimony came in, and from whomever it came in, it might have confused the jury as to the force of this particular evidence, because that is the only piece of evidence that conflicts with the employer's other evidence, right?
No. Well, I disagree.
Mr. Lindon's testimony,
I'm sorry?
Mr. Lindon's testimony corroborate that he
Yeah, I'd like to clear up.
So you've got the two, Lindon, and you've got the document, right? And that's basically it?
No, I'd like to clear up a couple things. First of all, you said the trial judge. This was ruled on by a successor judge who was not at trial. And so I
You
want
said she read the transcript.
Right. But I think the trial judge who sat through the trial, when it got to the time to do the jury instructions, made a comment that makes it very clear that that trial judge understood it was not filed with the government. And we've cited that in our brief. As far as
Made the comment in the presence of the jury or outside?
no, it was outside. It was in the charge conference. But my point being that the idea that there was some misperception at trial is belied by the record by the trial judge who tried the case, who said at the charge conference that it wasn't filed with the government, and everybody knows that. And I quote that in the brief. I paraphrased it here. Go by what I've quoted in the brief. So I think for the successor judge to come in later and to read this transcript and to make this leap that there was some confusion with the jury is unsupported by the record, and she was not in a position to do that. As far as Judge Sawaya's question about was there other evidence besides Mr. Lindon's testimony and the I-9 form, there certainly was. And first, just on the I-9 form, the most important part of this isn't its official nature, it's a party opponent admission. Think about what other context, civil or criminal, where you have a party make a confession under oath, and you would say that the verdict was not supported still.
Okay, well, what other evidence is there? Because their concern is that if you want to be an officer of the corporation, and he held himself out to be an officer, I think it was vice president, then you're an employee of the corporation. And stockholders usually don't assume the role of vice president, president, and officer of the corporation unless you're employed by the corporation.
Right, and so the other evidence was Mr. Dalton's attorney who drafted the corporate documents. He knew Mr. Dalton was the president at the time that the corporation was formed, yet he did not know whether or not Mr. Dalton was an employee of the corporation. And he had conflicting testimony that he was impeached on that. So their own lawyer said that a corporate officer may not have been may not have been an employee of the corporation. And I can actually think of many instances, Your Honor, where someone could be an officer of the corporation but not an employee. And there was certainly evidence in the record to support that from their side. That same attorney testified that it was not uncommon, and I'm quoting now, not uncommon for a shareholder to do certain things on behalf of a corporation. And then he said usually somebody would be employed by the corporation. Well, Your Honor, if I'm a juror and I hear not uncommon and usually, that tells me that it can happen. There are times it can happen that the shareholder act like that. The other evidence, Your Honor, is there was no salary paid to Mr. Lindon at the time he signed the stockholder agreement or beforehand. There was no workers' compensation provided, no unemployment compensation benefits. There was the DHC corporate secretary admitted that there wasn't a single corporate document by DHC establishing Mr. Lindon's status as an employee or a corporate officer before or contemporaneously to February and March of 1999.
Wasn't there some correspondence too between Mr. Lindon and maybe Radisson or somebody where, I mean, they didn't even know who Dalton was, I think. And is that the record?
Well, there was some correspondence.
February of 99.
Exhibit 10 is what I have, Your Honor. It's dated 1 month before the execution of the stockholder agreement, and it referred to Mr. Lindon and his partners.
Right. Yeah.
So
let me ask you,
I think this. I'm sorry to interrupt. Go ahead, Your Honor.
They get a new trial on damages, right? Even if they don't get a new trial on liability.
Well, we really get the new trial on damages because they messed.
But there has to be a new trial on damages in this case, right?
Absolutely, but the two issues are very distinct and will be
issues. Yeah.
and the evidence presented at both will be very different. I mean, the liability issues here are completely divorced from the damages issues, and so to require us to go through the expense of having to put on all the evidence again on liability.
You misinterpreted my question. You
I'm
answered
sorry.
my question. You don't need to get defensive.
I'm sorry, I didn't mean to be defensive.
I just wanted to see if there was still an issue over that.
Yes,
You
there's
concede
definitely-
that there has to be a retrial on that.
Absolutely,
Okay.
and I'm sorry if I'm defensive, and I should probably calm down a little. The first appeal, Your Honor, as you may know, we weren't allowed to put on our damages case because they convinced the trial judge of a certain theory of the law, and that got reversed on the last appeal. So yes, there's going to be. I don't think they should get the benefit from that, though.
Wasn't there a $180,000 nominal damage award or something like that?
There was, Your Honor, and we've conceded that was wrong. There's a bunch.
Well, how did that come about then?
Well, Your Honor, in the last opinion, this court said that was a mystery.
So you still don't know how that?
We don't, but I don't. When I've heard no explanation from, I think this is the critical point on this. I've heard no explanation as to how that finding in any way was related to or infected the finding about whether or not Mr. Lindon was employed in February or March of 1999. Everybody concedes that Mr. Lindon was employed from August 99 forward, okay? And there's been theories that maybe the jury was trying to do a severance package or was somehow trying to compensate him for wrongful termination.
Or maybe they just thought he got a raw deal and wanted to get him.
Right, but the fact that the jury made a mistake on one issue doesn't mean they made a mistake on the other issue. I mean, it doesn't follow.
I'm just trying to get to where we are procedurally.
Yes, sir.
You want us to reverse the trial judge's grant of a new trial in whole or only to the extent that it grants a new trial on liability?
Only on liability.
Okay. In other words, where'd the new trial on damages come from? The prior opinion of this court? Did that order that, or did this trial judge, is that subsumed in the order granting a new trial?
It's from the prior appeal. It's not.
So
it's not even really an issue on this appeal because.
Okay, so you want this opinion, this final judgment, or this order rather, reversed?
Want this order reversed in toto, and then that would mean there's been no damage determination. There's been the only thing we got to submit to the jury last time.
The damage issue is not really an issue in this case. It's not.
Not on this appeal, no.
Right.
You have an order. You have a mandate that mandates a new trial on damages, is what you believe.
Right. Well, because the last trial we didn't get to put on any evidence about consequential damages.
Do you have a mandate that mandates a new trial on damages?
Yes.
Okay.
Yes, sir.
All right.
Yes, sir. I think there's a lot of other red herrings in the brief, and I want to reserve some time for rebuttal.
Okay.
But they've raised the preemption argument for the first time in 7 years in this case, which I think demonstrates why you don't get a second bite at the apple here. It's not really before this court. They've stuck it in all the footnotes. If they wanted to raise that issue, they should have done it in a pretrial motion in limine. You go back, we're now going to have that whole issue to come up again on a third appeal, which I think is just unfair to Mr. Lindon at this point, that we've had a final determination on the liability and we should move forward on the damages as it relates to DHC. But I'm going to reserve the balance of my time unless the court has any further questions.
Thank you.
Good morning, Your Honor.
Good morning.
David King, representing Dalton Hotel Corporation and Dalton. It's our position that the standard in this case that the court should apply to sustain the trial court's ruling is set out in Hahn versus Medeiros, Judge Sawaya's decision, where he found that the issue is abuse of discretion. There's broad discretionary authority in the trial judge. You apply the reasonableness test. If the reasonable persons could disagree as the propriety of the order, then it should be sustained.
Doesn't the discretion seem to diminish if you're talking about a successor judge that didn't sit through the trial? And
there is a statement in one case about that in the Casillo case, but here, Your Honor, really you've got the trial judge who sat through the trial. Is there any question in light of her order that came up on appeal the first time that she would have granted this motion as well?
For example, he brought out the fact that, and he cited it in his brief, that there was a statement made by the trial judge that actually tried the case, that she knew that this document had not been submitted to the government. But yet we have this successor judge that seems to think that there was a lot of confusion on the part of the jury about that. Well, and so you have a successor judge trying to figure out and looking at a cold record, trying to, you know, whether this is against the manifest weight of the evidence and the credibility of the evidence that was introduced and that sort of thing. So isn't there a diminished level of discretion that we give a successor judge that didn't try the case?
I think in this situation you apply the reasonable person's test. You look at the evidence. You look at the trial judge's order, which would have.
Why would this court be in the same position as Judge Blackwell?
This court is certainly in the same position as Judge Blackwell was when she did it.
Right.
But you've got to work with the order of the first judge, and you've got the order of Judge Blackwell, who did a very studied.
Here's the problem I'm having. You know, we talk about, well, there was a lot of confusion on the part of the jury about this particular form, and yet we know that the trial judge that actually tried the case knew, based on Hertz or Britt's testimony or whatever, that the form actually wasn't submitted. And she knew that really wasn't a confusing issue. And we've got the testimony of Lindon, we've got that form, and we've got some other testimony from the attorney that drew the document indicating that maybe he didn't start as an employee until 1999, whatever that date is. And so you've got all this evidence that the jury heard, and the jury heard the fact that the testimony that this form was not submitted to the government, and the jury made their decision that, you know, that there was liability here. And why shouldn't we let that stand? And there's a new trial on damages.
I don't think you can say that the first judge would have not granted the verdict as being against the manifest weight of the evidence.
As to that one issue where there was some confusion about whether this document was submitted or not, she knew based on what's in the record that it hadn't been submitted, and that wouldn't have been an issue to her.
But that was never provided to the jury, and let me just discuss with you the evidence that came before the jury on that point. In the opening statement, they pointed out that the evidence will show definitely that agents of this company executed government forms indicating the employment began right then and there. And these are documents submitted to the government. You caught a little drift of this during the voir dire. Now, that's Mr. Lindon's counsel in opening statement. Then in the questioning of Mr. Lindon.
But pardon me for interrupting, but the counsel admitted that had been harped on until and I forget the lady's name, Britt or her or whatever her name was, testified. The secretary.
Corporate secretary.
Said we didn't send it, and then after that, it was the
not so, Your Honor.
That argument.
Not so. I'm just going to take you through it.
Okay.
In the testimony of Mr. Lindon, he was asked, "Has anyone on behalf of Dalton ever indicated to you or to the U.S. immigration that somehow your employment began at some date earlier than 8/1999? Answer: no, they didn't. So now they've skillfully interjected the U.S. immigration into this issue of his employment. And then on cross-examination, he's asked, now the reason you're contending you're an employee in August of 99 is because that's when you started drawing a paycheck, correct? Answer: that's when I represented to the federal government that I became an employee. I mean, if that's not telling him that information got to the federal government, I don't know what is. Then Ms. Hurt testified later, and then in closing, they say...
Well, she testified it wasn't submitted.
She testified that it wasn't submitted. Right. But now we've got Ms. Hurt against the federal government here, you see, because then they say...
The jury heard her testimony.
The jury heard her testimony, and then they heard the other side say in closing, this is a form that everybody who works in the United States must complete to be completed and signed by the employee at the time employment begins, referring to the form. It was generated because the American government says if you don't generate it and they come in and get you, you've done something wrong.
Is that a misstatement?
I think that is a misstatement under these circumstances when the only issue is when does the employment start. And then he goes on to say, this document was not created by us. That document was created by the government. It was completed by them. They said this man started employment 8/1999. If they didn't tell the truth, somebody could be in trouble. Well, they have the government in this employment relationship, and so.
It's fair to say that there's a conflict in the evidence then, because I guess maybe there's a conflict in what the lawyers may have said, and possibly what was inferred to by Mr. Lindon and some of the other witnesses, and then what Ms. Brett said, or the secretary said, that it wasn't submitted, and the jury resolved that conflict, and that's that.
And so it wasn't the issue of filing it, Your Honor. What Judge Blackwell said in her order was the fact that the jury was repeatedly led to believe the document had special significance. It was offered as having an official government imprimatur as a matter of law that it didn't have. The jury was tasked with weighing Hurt's belief against that of the federal government. The conclusion was the jury was deceived as to the force and effect of the I-9. Now remember...
I have a hard time with that.
Well, in the context of that, Your Honor, when you think about it, though, this is a man who worked for the company full-time from October of 1998 until August of 1999, when they say he became an employee. The only thing that occurred in August of 1999, there was no testimony about I worked out an employment deal then. What happened was he simply signed this I-9, and his salary started at that time because a loan closed. Before that, they hadn't been able to pay a salary because the loan hadn't closed, and everybody knew that.
Would you agree that that document is essentially an admission against interest? I mean, you have this document that was executed and that was signed, and it says he starts on whatever the date was.
And the first
admission against interest.
And the first judge said that it was uncontradicted, that there was an explanation that it was a mistake, because the corporate secretary testified it was a mistake, and she gave a very credible explanation to that.
The jury heard that too, didn't
it? The jury heard that. Okay. And as a consequence, but the fact remains...
And the corporate secretary was Mr. Dalton's
secretary. Legal assistant, yes.
That too, right?
What's that?
The jury heard that?
The jury heard that. Yes, Your Honor.
The jury heard it all, didn't they? They'd heard everything, and they just came to the jury heard all this stuff.
The jury heard that, but it had a special force and effect. Right. But the second thing the jury heard was they heard Mr. Lindon take the position that he was a shareholder when this was going on. And the problem with that argument simply is that there was, you can be a shareholder and do work for a corporation, but only if there is a special delegation of power to the shareholder. That didn't occur. They tell you, they say in their brief that you ought to infer that that occurred. But the problem is, in the record, there is clearly testimony from Mr. Dalton and Ms. Hurt that that never occurred. They were specifically asked that.
And the corporate minutes show that they had made Mr. Lindon vice president?
The corporate minutes don't show that any of them had been made an officer. In other words, there were no corporate minutes that showed anybody was an officer at that time. But Mr. Lindon held himself out as a corporate officer starting in February of 1998 under his own admission. In other words, they testified, Mr. Dalton and Ms. Hurt testified, he'd been a corporate officer since October of 98.
Was that after when he held himself out as vice president, was that after the shareholder agreement was signed?
That was before the shareholder agreement and after the shareholder agreement. In other words, through that whole period of time, because remember, he's got to be something between between October of 1998 and August of 99. He couldn't be acting as a shareholder because he wasn't.
Their retort to that argument is that, well, we had testimony from the lawyer that drew this document that says that, well, this is sometimes shareholders do perform.
Well, the lawyer was being a lawyer. The lawyer knows what we know, that yes, there are certain circumstances where that could occur.
The jury heard that too.
But
So the jury heard the fact that, well, there are shareholders that do things for the corporation too and don't draw a salary. I mean, it makes sense to me that if you're an officer, if you're president, vice president, or whatever, you're an employee of the corporation generally, and you're hired to perform a service, and you're to be paid for your services. But even the lawyer testified that's not the case all the time.
Well, when there is a special delegation of duties from the corporation, but that's not what occurred in this case, Your Honor.
I got two questions for Mr. King. Can I ask two questions?
Yes.
Mr. King, do you agree with counsel that if we were to reverse this order, that there's still an order out there or a mandate that requires a new trial on damages?
Yes, Your Honor.
Okay. Second thing I wanted to ask you was, if you, now, this is a hypothetical entirely, but if you retried the case with the same evidence and you got the same verdict on liability, are you entitled to a new trial because the second verdict is against the manifest way of the evidence?
I think you'd be back on appeal. I mean, I don't think there'd be any automatic ruling in that situation.
Well, I mean, you got a new trial. In other words, if you tried the case a second time on the same evidence and got the same verdict, do you have the right to go ask the trial judge for yet a third trial based on the same grounds?
I think it's unlikely you'd be trying it on the same evidence, but
that's why I said it was a hypothetical.
Right. If you did, I don't think you would get a third trial in that situation. But I'd like to point out that there is a third reason that it's very clear that we're entitled to a new trial, and that is the inexplicable damage award. Here we had a damage award of $180,000 for nominal damages. That is so far from any reasonable understanding of what a jury acting appropriately would have done as to raise the same issues in Brown versus the state of Stuckey. And that was the same situation in 2000. Supreme Court considered a case.
Obviously, that's a mystery as to where that figure actually came from, and I think even the opinion from this court basically said, well, we don't understand how they arrived at that. But his retort to that argument is, well, just because a jury was wrong on that particular issue doesn't mean they were wrong on the liability issue.
But the evidence, I think the suggestion is, in a state of Stuckey, the Supreme Court said, in just the same kind of a situation.
You're saying then that any error on liability flows over to the damage issue, and any error in the damage issue vitiates and flows over to the liability aspect.
What I'm saying, Your Honor, is just like the Supreme Court said in the Stuckey case. When they get it so badly wrong on damages, you cannot but say that the liability award is tainted as well.
It's a whole bubble off a plum.
What's that, Your Honor?
It's a full bubble off a plum, right?
I'll buy that, yes, sir.
Yeah. Was the jury told that to make a nominal damage award?
The jury was instructed to give a nominal damages award. They were instructed nominal damages are the damages that serve only as a symbol of an obligation that's owed and should be limited to a fairly inconsequential amount.
But the jury disregarded the instruction.
They disregarded that instruction, and you've had 5 judges now that have looked at this and all say it's improper and it's wrong. And then if you look at the Supreme Court of Florida in Stuckey, they looked at exactly the situation. The trial judge found that the damage award was so inexplicable that it must have tainted the liability award, and the Supreme Court upheld that. And he's going to say, well, the only way he's got to distinguish that is he's going to suggest to you, well, at the start of the trial judge's order, there was some information about whether there was some jury impropriety. But if you read that decision carefully, and I suggest that that would be appropriate, you'll find that that jury issue has nothing to do with the ultimate outcome of both the trial judge in granting the motion for new trial and in the Supreme Court in their analysis. They simply look at the damages award. They say the damages award was clearly unsupportable, and they conclude that the liability award had to be tainted as well. Now,
well, when you're awarding nominal damages, there's really no standard, really, is there to
well, the judge instructed
just
him.
what you think is reasonable, and if the jury, I mean, what standard does the jury have to say, well, you know, this is how we're going to calculate the nominal award?
Well, the jury has the instruction.
They said they have to be inconsequential.
That's right. And these weren't.
So, but they probably thought that 180,000 was inconsequential. But other than that, that's kind of a nebulous, very vague standard, isn't it? I mean, to say that, well, the jury disregarded the instruction when really it just said inconsequential, or...
Well, I think it's
inconsequential.
I think you've had 5 judges already look at that and say that they missed it pretty badly, Your Honor. And there's no basis of it. And for them to suggest that, oh, it's just a severance package for Mr. Lindon, they weren't instructed to give Mr. Lindon a severance package. That's not an issue in the case, and that suggests that the jury got it very badly there. Now, as far as I saw a subtext in some of the questions that I wanted to address, and that's this business about when there's evidence on both sides, what's the situation? And he cited 4 cases in his reply brief that said if there's conflicting evidence, you don't grant the motion for new trial. All of those cases that he cited in his reply brief are cases where the trial judge denied the motion for new trial. And so when the appellate court looks at that, they look at it and they see the reasons, and they say, well, if there's conflicting evidence, we're not going to reverse the trial judge in denying the motion for trial. But 41 years of jurisprudence in the Supreme Court, from Cloud versus Fallis to Brown versus the state of Stuckey in 2000, established that when the trial judge has granted a motion for new trial, even that will be upheld if the court concludes that reasonable persons would disagree about the propriety of the order, even if there is substantial competent evidence in the record. Now, this court has already looked at the evidence in this record, and they said there was significant evidence supporting Dalton. There was some evidence supporting Mr. Lindon, and that some evidence is just the I-9, his self-serving testimony, and the fact that he didn't get a salary. And all those things are and were easily explained, and according to the trial judge who listened to the case, a very credible explanation was given for those. She felt that there was a miscarriage of justice in this case, the original trial judge, and now the second judge, who's looked at this very carefully, suggests that there was a miscarriage of justice. When this came back from this panel, the first panel from this court, you can certainly read that decision as suggesting that they felt or considered that this analysis would be appropriate on manifest weight of the evidence.
The prior panel just said go back and consider the motion for new trial.
They did, under Smith versus Brown as the hallmark of the standard, which of course is a situation where there's evidence on both sides.
They didn't tell us what the outcome of that should be.
They did not tell you what the outcome should be, Your Honor. That's just me reading the tea leaves. I simply submit, though, that you've had 2 very good trial judges look at this very carefully and conclude that there was a miscarriage of justice. That's the purpose of the motion, of granting the motion as being against the manifest weight of the evidence. And under those circumstances, there should be a new trial on liability and damages at the same time when we go back to the trial court.
Thank you. Thanks. Why don't you address his argument that the jury got it so wrong on the damage issue under Stuckey that it flows over into the liability issue and tells us that they got it so wrong on that one too.
Well, Your Honor, we don't do that with judges, and I don't see any reason to be different with the jury here. In this very case, in the first appeal, this court upheld the judge's rulings on, as a matter of law, summary judgment rulings on tort, but reversed on other things. I mean, the two issues are so different and apart from one another.
Well, but this isn't just the jury picking a number that, you know, this isn't just a jury that was given a general instruction on damages and they picked a number that was not consistent with the evidence. This is a jury that disregarded an instruction from the trial court, right?
Well, I wouldn't be.
Isn't that misconduct?
I wouldn't. No. I think that's overly harsh.
Didn't they disregard the rather rather clear instruction about what nominal damages are?
First of all, I would disagree that the instructions on nominal damages are clear. It says
$180,000 is not inconsequential.
I understand. We've conceded that, but there was no evidence presented at this trial about damages. None.
Well, I mean, because the trial judge instructed them with nominal damages, right?
There was testimony that the value of the stock was zero, correct? The book value of the stock was zero?
That may have come in at some point, but that really wasn't an issue because of the judge's pretrial rulings.
She cut you off on it.
I mean, it may have come in somehow, but it wasn't, there was nothing, the jury was given really no real guidance on how to determine these nominal damages. I mean, I'm not going to repeat the instruction that my brother just said. I can go back and read it. I think to a layperson, in trying to figure out what is inconsequential, when that's all you tell a layperson, and you're dealing with...
Was this a bunch of Donald Trumps in the jury that...
Your Honor, this was a multi-million-dollar hotel deal, and there was testimony about that. And so, and there was testimony about Mr. Lindon's salary. And if you look at a multi-million-dollar hotel deal, I'm not saying it's right. As I understand, we, as you know, the lawyers, the judges, we see it's wrong. We've conceded that. But you've now made this. You've said to me this was juror misconduct. I think that's overstating it.
Well, there's a distinction though between a jury that gets a general damage instruction and renders an award that is subject to challenge because it's inconsistent with the evidence, and a jury that renders an award that is contrary to an instruction given to them by the trial judge. Isn't there some distinction there that you see?
No, I don't. I
think,
and I do. I'm sorry.
Isn't this like a Stuckey case? I mean,
no, and that's what I was going to get to. There was juror misconduct in that case, and he's alluded to it and tried to dismiss it. But the jurors were out actively independently investigating the case. And I go through in our reply brief and go through that pretty thoroughly, more than I can here, and you should obviously read it closely. But there's no evidence here of any type of juror misconduct like we had in Stuckey. And so I think to penalize Mr. Lindon on the liability finding when this nominal.
Well, I think in Stuckey, what the court I think was trying to say was that was so egregious that we can't. But if the jurors were doing that, then that's so egregious that we can't put any confidence in any issues that they may have decided, including liability.
There was affirmative evidence about the jurors engaged in misconduct. I mean, there was post-trial motions with regards to juror interviews and things like that. We don't have any record like that here. All you have is, I think Judge Sawaya put it best, a nebulous jury instruction that's, I think, is difficult for a layperson to understand. There was no evidence presented to them, and they came up with a number. Probably what should have happened in hindsight is that should have been decided as a matter of law. I don't know why the nominal damages ever really went to the jury in hindsight, but I don't see how that small piece can in any way have any determination on the separate issue about what was happening in February and March of 1999. I mean, there was evidence on each side about what was happening in February and March of 1999. There was the evidence about the I-9 form. There was, you know, I wanted to point out too, there was evidence that when Lindon and Dalton met, Lindon was a self-employed consultant. There was not a single contract executed by Lindon before the stockholder agreement. The language in the stockholder agreement itself, it says, if any employees, indicating that maybe nobody was an employee of the corporation. And the testimony concerning Mr. Dalton's relationship with Gray Robinson, where he denied that he was an employee for Gray Robinson, even though he was working for Gray Robinson and getting compensation from Gray Robinson. And Gray Robinson testified only that what Mr. Dalton was not. And that ties into this whole stockholder theory too. That was not Mr. Lindon's theory of the case. He only had to prove at trial what he was not. He was pressed on cross-examination, what were you then? And he said, in a few instances, well, I was a stockholder. He's not a lawyer. He came up with something. What was he is amorphous, but that he didn't have that burden of proof. And he more than met his burden of proof. And at best, the evidence here was in equipoise. There was certainly, you can't say there was almost no evidence for Mr. Lindon. And this court is exactly like the successor judge in the same position and should reverse and remand for the trial and damages.
Okay, thank you both very much. Well argued on both.